Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to pick up on Ohio versus Billy Wagner. So this is another pre-trial. We've had a couple now that we've been following. And this is an interesting, sad case out of southwestern Ohio. Kind of down where Cincinnati is. I think it's a little east of Cincinnati. So Cincinnati is right on the border of Kentucky and Ohio. So let me just, for those that don't know, so George Billy Wagner III, he is up for trial for his involvement with deleting an entire family, right? So the victims included Kenneth Rhoden, who was 44, Christopher Rhoden Sr., who was 40. Here, let me pull up. Let me go back to here so we can see. Right, so those are the people, unfortunately, and it was all over. It was all over a little kid, a little baby. That's what they were. These two families were feuding. All right, so we got Kenneth Rhoden, who is 44, Christopher Rhoden Sr., who was 40, Dana Rhoden, 37, Gary Rhoden, 37, Clarence Frankie Rhoden, 20, Hanna May Rhoden, 19, Christopher Rhoden Jr., 16, and Hanna Hazel Gilley, who was 20. So they are, well, his wife and his two sons have already gone to trial, right? George actually went to trial and he was found guilty and he's put away for life. Jake and Angela took plea deals and we saw their sentencing. I think that was in January. We saw their sentencing then. And now they got Billy. Now they got Billy here as the, I don't know if he's the ringleader. I think it was more Angela was on the phone. She was kind of making sure, things happened the way they happened. It's sad. They shot. I think Jake and George were the ones. They were the trigger. They were the trigger people, and it was sad. So it was back in November of 2018. Let's see. What else can I give you as a backstory? Okay, so it was a custody dispute between Jake and was it Hanna Rhoden? I think it was her. It's been a while since I've thought about this trial now, to be quite honest. But yeah, it was over a little kid, a little baby, unfortunately, a little child. So who is with us? Sarah in Shockenhalla. Good to see you. Haven't seen you in a while. Hola with an H. Listening in but can't chat. Hello to you. Marley Mum. Good to see you. And Therapist great seeing you. Nanar, hello to you. Lily Wayne, great seeing you as well. Golden Girl, thank you for the little recap. Yeah, we'll do another deeper dive as it gets closer. Terry H, how are you? It already started, but I was busy doing something else this morning, so it's actually over. It started and it's over, so we will be able to fast forward and zoom. So, hey, MEG, how are you? And Lily Wayne, good to see you. Wendy's with us. Widespread Panic, great seeing you. Green-Eyed Cat, good to see you. Ramsey, nice to see you as well. Thank you for joining us, you guys. Appreciate it. Trial Junkies United, I know you're in here as well. Only Fan. Helen, good afternoon. Hey, Jimmy. Oh, you're new to the channel. You live in Pike County. Awesome. Well, Jimmy, I think this is supposed to start May 30th, but we are going to be covering Lori Daybell because we have a courtroom insider there. Plus, we've already covered her latest one. Because I would say, boy, if you go to it. Babaloo, good to see you in Fala. Terry H, you're here. Awesome. I want to think it's May 30th. I think I heard May 30th. So, I think I heard May 30th. Sure Life Creations, you are here. Awesome. All right, let's get into it. This is, the audio is really low. I don't think they're using mics, so we bumped it up as much as we could. So be prepared for that. There's no closed captioning, so that stinks. So hopefully you guys can hear it. It does, I'm I'm gonna ease it in because it comes flying in. But hey, Gordon, nice to see you. Let's see. What else could you possibly have to do than that be with us? Yes. All right, so May 30th now written in my trial journal with a pencil. Yep. All right, so we're gonna, I turned the volume down because it comes in, because we bumped it up so loud. So anyway, just be prepared. Volume's a little wonky. And let me see, I gotta move myself over here. All right, so here we go. This is, this started, this was this morning, but we're catching up on it right now. So I'll see you guys on the other side.
Amount of informality that's appropriate, as long as it's not system. So, ready or are you? Okay, thanks. CR 157, State of Honor versus George Wagner III. The case is set for regularly scheduled appearances. The attorneys of record are going to appear today, and first issue to deal with is Mr. Wagner's not here, so how does the defense handle this?
Thank you, Madam. Please support Mark Collins on behalf of Mr. Wagner. Your Honor, we would formally waive his appearance for this hearing. This is kind of a legal hearing with some arguments that are going to be made, as well as some procedural aspects. We're very grateful that Mr. Wagner was moved to Pickaway County. We were able to see him much more frequent because of that. And we've explained that sometimes he might be here, sometimes he might not, in general, depending on how many of these status hearings we set. And so he was okay with that concept. So for the record, we would formally waive that. It's my understanding that for whatever reason, he has not even been, no one's there to pick him up yet. So, and since everyone's here, ready to go, including the victim's family, we're fine with waiving that at this point in time in his presence.
Okay, thanks. Is there any position the state has on that?
Obviously, I believe this is the court's decision if they're okay with that. My only trepidation a little bit is that even that kind of case, although currently the specs have been dismissed, I think in that situation, you don't know that his appearance can be waived. I think he has a right to be here for every hearing, but I would defer to the court on this.
Okay. I would just want to let you stake out your position.
I'm sorry, what?
I wanted you to stake out your position, so you won't have one to speak of.
Deferring to the court.
Yeah. Something else, Mr. Ryan?
No.
So it's a privilege and a right of the defendants to use or waive. I think he fully can. I mean, the circumstances of a death penalty case, like every case, need to be considered to their fullest extent. So I'm willing to accept the waiver proceeds. We can reconstruct the record if we need. It's how you want to handle it. So I appreciate the fact you want to be productive when it comes down to it, Mr. Collins, Mr. Hayes. So we'll go ahead without it. I sent an email out where I outlined what I thought we needed to do today. And it doesn't necessarily have to be in that order because I didn't bring the email. But there are a lot of issues to go with. So I'm willing to, I guess, tip it off. But there's motions from the victim's perspective. So, Ms. Gall, how do we want to go about those? Do you have a preference?
Good morning, Your Honor. Maureen Gall on behalf of victim TR and representative TR. I don't have a preference. I think based on the defense's response.
Hang on. Now go.
Based on the defense's response, pointing out that there hasn't been a legal finding of TR as a victim, it probably makes sense to start there. If he's not found to be a victim by this court, then he wouldn't have any rights after that. So that might be the best place to start. And that was the most recent motion that was filed on April 7th, 2025. The designation as motion for designation as victim and request for judicial notice as victim representative.
Is that too fast for me?
little bit. We're all right.
Sorry, I can slow down.
Most of us understand that we speak faster than people can write. We don't think about it because it's not our job. I've suggested to the court reporter many times she needs to stop the whole thing. She will.
All right, just wave me down.
So when Mr. Collins hands her papers while you're talking, it gets a little overwhelming. But we all do it inadvertently. No big deal. Did you get on that from everybody?
Yes, sir.
Thank you. So there was a response from the defense. We'll just take it in that order. You're welcome to go first with your motion with regard to victim designation.
Okay, Your Honor. Thank you, and may it please the court. So I guess procedurally, it might make sense to go through how we got here. Judge Corbin did issue a decision denying the defendant's change of venue request back in November of 2023.
Were we on victim's representation?
Yes, but they raised the issue in their response to change of venue,
I
so
know,
I
but
wasn't sure.
I asked you to talk about the victim representation, not change of venue.
Okay.
Thank you.
So the victim definition under Ohio Constitution, Article 1, Section 10AD, and Revised Code Section 2930-01H is an individual who is directly and proximately harmed by the criminal offense. Victim TR is the brother of a deceased victim, in this case, Rhoden Sr. I do believe that the murder of his sibling does cause direct and proximate effects and harm on him, both emotionally, psychologically, and then there's the financial aspect. He has, taken the time to drive to and from court, to attend these hearings throughout all of the defendant's cases, but most recently this one, he is here today. He's taking off work in order to be here. These are ongoing effects that are going to continue to affect the way he lives for the rest of his life. There are several courts in Ohio that have upheld the victim definition in a very broad circumstance. They've held that banks are victims. They've held that an Uber driver not identified in an indictment was a victim. They've held that a law firm was a victim. And most recently, the 5th District did uphold a victim definition for parents, siblings, and nephews of a deceased victim. So I would submit that he does meet that legal definition as a victim directly. As far as the victim representative portion of this, there is no law that I'm aware of that requires this court to designate a victim representative. So I would ask the court to take judicial notice that he is acting as a victim representative in this circumstance. I do have some updated victims' rights request forms that I can file with the court where victims in this case have designated him as a victim representative. I think notably it's important that we look to revise Code Section 2930-02 that allows a victim to exercise their rights with a victim representative or have the victim representative exercise those rights on their behalf. So taking judicial notice that he's acting in that capacity does not dilute any other victim's voice in this process. Thank you, Your Honor.
Thank you very much. I'll come back at you, but go ahead, Mr. Hazel.
Your Honor, we leave it up to the court's discretion if TR is a listed victim in the case. We're not taking an objection to that at this juncture of time. I think it's within the court's purview and within the court's discretion. We do take into account, and we briefed it, so I don't need to go through everything with this. If they have standing to argue this, and they have standing to argue against the change of venue, we believe that they do not. And the statute doesn't provide them that standing to do that, so we reject on the record based on that. But whether TR is a listed victim, we leave that to the court's discretion. However, we do object to the standing that they would have to argue motions to be part of the proceedings.
Which is why I cut her off early.
I'm sorry?
Which is why I cut her off early when she went the other direction. Back to you, Ms. Cole.
Your Honor, in response to standing. Victims do absolutely have standing to assert their rights and to challenge any denial of their rights.
What are their rights?
They have the right to be present, the right to be heard. Those are the two that are most prominent today.
No. You don't get the budget. What are their rights?
They have rights under the Ohio Constitution.
I understand. What are they?
Section 10A. You want me to list all of them? I don't have them in front of me, but they have the right to be present, the right to be heard, the right to restitution, the right to object to unreasonable delay, the right to fairness and respect for their safety, dignity, and privacy. They have the right to an attorney, but not an appointed one, and that's under the revised code section. I think that covers all the rights that I would assert here today. The three that we would be asserting here today are the right to be present, the right to be heard, and the right to dignity and respect for their safety, dignity, and privacy.
Yeah, the right to confer with the attorney for the state, and
Yes.
I brought up previously that the state doesn't represent the victims.
Correct, Your Honor, I would agree.
Essentially, the state's attorney represents the state and talks to the victims, doesn't give them advice, doesn't owe them a duty, right?
Correct.
Now, if there's 10 enumerated rights, you did a fine job checking them off.
Thank you.
But to steal Mr. Hayes' thunder, I don't know that you represent the state any more than the state represents your client, correct?
I do not represent the state. I am not a prosecutor.
That was your point, right, Mr. Hayes? Okay. Is this the first request, Ms. Gall? Like, I didn't read the whole file. In this case, was there a previous request to designate TR as the victim's representative?
No, Your Honor. I only brought that to the court's attention based on the response and the change of venue motion from the defense.
Okay. Like, I only started this last June, and you got here after that.
Yeah, I didn't come in until December, so I'm behind.
Like, in your experience, has there been a deprivation of your client's 10 enumerated rights?
Your Honor, we appealed the change of venue decision from this court based on the argument that they were not heard at that hearing about how a change of venue would impact their right to be present. And the Fourth Appellate District said that the decision we appealed was not final because the venue had not yet been changed, and so they couldn't weigh in on anything else.
Yeah, and they went farther than that, actually, to discuss what you're allowed to participate in, Mr. Hayes' standing argument. I'm just going to want to know if Ms. Canepa is going to cede you the right to talk about her objection to changing venue. So let's put you on the spot and let me know if you consider her now representative of the state to argue the motion that you oppose.
Your Honor, yes. The state's interests align with the victim's interests in this.
Yeah, but that's not the same as ceding representation. So I need to know if she's speaking on your behalf.
Your Honor, I can answer that.
I didn't ask you. I want her opinion because it's her turn to talk. I know you have an opinion, but I need her position.
I think it's tricky, I guess, because this court has made it very clear that the state does not represent the victim's rights. And while I did make those arguments during the change of venue, some of those arguments, the hardship that this created on the victims and basically operates as an exclusion of them from the hearings because of those hardships, it was our understanding from the court's position that if they wanted to be heard on that matter, they needed to have their own attorney asserting those rights for them. And that's when Ms. Gallup became their attorney, so that she could directly represent their interests. Again, I feel like it's still a state argument, the hardship on the victims, the hardship on the witnesses, all that stuff. So to the extent that her arguments are our arguments,
That's alignment. I agree that you're aligned on your expectations and goals and philosophy. But mine's a question of representation and whether her speaking is you speaking. Her legal duty to represent a client is your duty to represent a client.
I mean, she's not appointed as a state's attorney, representing the prosecution of this case. But, again, I mean, she is representing the victim's interest, which we also believe we are supposed to be asserting. So, I know I'm not answering the question.
Yeah, and I'm not sure if it's a lack of knowledge or inconvenient, because it's a huge deal with regard to who represents whom. Like, I don't want to hear a lawyer speak for some other party because they can't. The way you can't represent the victims, in my opinion, is the way the victim's attorney can't speak for the state. I have to look at one table and realize there's different clients. I do it all the time. So do you with regard to multiple defendants in trials simultaneously. Right?
Sure.
It's a big deal. And we can't blur this line. She's going to want to speak on reconsideration of a motion. And I got to decide if I'm hearing you when her mouth moves legally.
Well, I do intend to provide supportive arguments in this matter.
Yeah, but now we're back to the waffling. She speaks. Go. It's a. First of all, like there's a lot of discussion in the judiciary about the new rights that are co-equal to the defendants because of the Constitution. Right. We're all getting used to a law that we thought we knew, but we're watching it being expanded and contracted and explained. I put in my routine regularly now that the state doesn't speak for the victim, nor give them advice. And if they have the wrong impression, it's their wrong impression. There's no legal duty. No victim's allowed to sue the prosecutor for bad advice.
Right. No, I mean, obviously Ms. Gow represents the victims in this case. I mean,
period. Only.
Period.
It's a big period. It's a big only. Right? Would you agree?
I believe so, yes, because there may be times where her position is different than the state's.
Okay, I don't think this is hard, but it'll get hard when we start applying concepts.
Yeah, and again, and that's what I was talking about, kind of that trick back, because while I would be happy to carry the torch for the victims, this court has made it clear that I cannot. But in order for them to...
No, the law makes it clear. I'm just delivering the law.
Okay.
It's not a discretionary item. It's a huge deal.
Okay.
Because I get abuse of discretion thrown at me when in fact I'm just speaking what the law requires me to say.
Yeah. But then in order for the victims to be heard and there to be any real meaning to that requirement, they have an attorney and she needs to be heard.
And as far as I know, I've got to ask her again, she's had that opportunity. Like I try to acknowledge her every time she's gotten here and invited her to sit in the front when she chose to sit in the back. So there wouldn't be the impression it's a lesser relationship. Like, am I supposed to have a seat at the table for the victim representative, Ms. Gull, moving forward the same way the state has their representative right behind them? I'm like totally willing to accommodate that. But like people have to talk to me about their expectation of their rights, because if he's designated the victim representative, do I pull another table? Do I offer you another table when you get the choice? Like I'm not trying to step on anybody's rights. I'm trying to get it right. But you have to talk to me about what you think's going on, and then I have to decide if it's the right application of the law. Okay? So like run it through your list of things and understand is, do you want your victim representative who's sitting at counsel table or not, if I designated that? Go. Yeah, go ahead.
No, Your Honor, that's not something that I'm asking, and I don't think that's something that victim TR runs it, and you have to sit with the
Yeah,
family.
thanks, that helps me. But if in 4 months you came back and I never asked, and you didn't request it, I get second guessed.
Your Honor, not by me in that circumstance. I would like to make a clear record on who I represent, though. I don't represent the state's interests. I didn't in my motion, my written motion, and I won't here today make arguments for the state. My sole purpose as the legal representative for victim TR is to make sure that his voice is heard, and the effects of a change of venue would implicate his right to be present at trial. There are hardships that the entire surviving family would see from that, and that's all I'm here to present today is that victim perspective. I don't think that there was an opportunity for that in the last hearing, and the appellate court stated in their opinion that the appellant didn't ask for that. They weren't represented at that time. I don't think most victims would stand up and object in a courtroom in the middle of a hearing, and I think that's an unfair assumption or expectation on the victim. So all I'm asking is that you reconsider the decision you made with voices from the victims, specifically explaining to you the hardships that would be put in place by a change of venue.
Equally unfair is for somebody sitting at counsel table to impute to the court knowledge of something that was never raised. And that's why I asked specifically, has there been an occasion where the court inadvertently or intentionally violated any of your rights, any of your client's rights, any victim's rights? Like, I want to know about it so I can not do it again, because nobody said anything, so therefore silence is acquiescence until the second guessing shows up. Like, it happens all the time. I don't find fault with it, but if it's judicial second guessing, like, I don't want to get hung with that again, ever. I want to learn. So that's the segue then, is if I designate a victim representative and we have an opportunity for a representative to speak, who do I ask to speak? The victim representative or anybody who is related and is a victim. Like, did I just lessen rights by designating a victim representative because I said there's one victim and the other 5 people that have a right to speak, in my opinion, now don't? So you want to chew on that since you did the segue? You want other people to speak, right?
Yeah, so the law says that a victim can exercise their rights on their own or with a victim representative. So the law supports that all 5 of those victims in your hypothetical situation would be able to speak.
Yeah, I'm going to give that. I'm going to give them that.
Okay.
Let's understand, I'm not trying to limit your rights.
Okay.
But I don't want you to inadvertently tie my hands by designating, asking me to designate, right? And then all of a sudden you find out that you closed the door that I didn't think should have been closed, and I'm stuck with it. So I don't intend to limit anybody's rights. At the sentencing hearings, people spoke their minds forcefully and appropriately, right? And we're going to do that as long as it's appropriate. I just don't want you to inadvertently limit what I think is appropriate.
Yes, Your Honor.
Okay.
The Victims' Rights Request Form allows victims to designate a victim representative, and that victim representative can receive notice on behalf of them.
Talking about this.
Yeah.
Right.
So that would be my argument submitted, is that even if this court did take judicial notice as that TR is acting as a victim representative, that doesn't tie anyone's hands as far as the rights that other victims can exercise with him or on their own.
The problem with forms is they imply things they don't mean to imply. Because here they list a victim, singular, and then below it they say victim representative, which I think means an advocate or a lawyer. Like, I'm not intending to limit anybody's rights, but if the defense hears a lot of things that they think are damaging, and wants me to say they don't qualify as a victim, then I got to get my hands wrapped around what you asked for and whether they're right. I don't have this form. You have a victim rep. They get one very damaging statement, not 5 or 15. Right? Like I don't tend to be narrow in my application of victims' rights. But if you close and tie my hands, then that's on you, not on me. That's the whole concept of invited error.
Yeah,
Still.
strategy, right?
No, it's not strategy rights, it's substantive rights.
Okay.
It's because you represent TR, right?
Yes.
Well, what about all those other people? Do you represent them?
I don't have an engagement letter with each victim in this case now.
See where this goes? Like,
But
who's the next
he
victim?
is just, that's why I'm asking that this court take judicial notice that he is representing the interest of
Well, I think
many
so.
victims. I think all of the victims in this case are in alignment with, moving this case forward and hopefully achieving justice, I think is.
But if they're not aligned, how many victims, lawyers do I get? 5, if there's 5 victims?
Well, I
9?
only know of 3 in the whole state, so I don't know. If you get 5 or not, we have to find some more.
I'm not finding them, but they have the right to get their own.
Right.
Right?
Yes.
Alignment's a really cool thing until it's not.
Correct. But I think as long as they are in alignment, a victim representative can voice that alignment and that interest on behalf of many individuals that are unable to attend each and every hearing for whatever reason, whether it be health, school obligations with the orphaned children, and I don't want to get into an argument.
No, this is healthy discussion.
Okay.
Like, this isn't argument.
Okay.
It's argument, but it's not argumentative.
Right.
I
That's
let
what
Miss
I meant.
I let Miss Canepa come at me.
Okay.
And some people thought it was like disrespectful, when in fact I found it engaging. Like she raised her voice, but I wasn't offended because it was a heated, passionate issue. Like, would I let her do that again? Yeah, as long as she was professional and like engaged, didn't take it to a personal level, and she didn't. Like that's that's what we do in this room, right? If you don't have like a firm conviction in your position, just get out. Just don't demean the judge or the system or take it personal, and we'll all get along fine.
We're all on the same page.
Wait till you have to tell one of the family members that you can't listen to them because it's not consistent with your client's position. And good luck figuring out what to do, because Ms. Canepa faces that, Mr. O'Brien faces that risk all the time when they have to figure out who they listen to when they're just giving information. Right? Been there, done that. I got this t-shirt. I got the scars on my back when the victims turn on the prosecutor. We just sort it out. Like if anybody says easy today, they don't understand what we're doing. Okay, do you have anything else on the victim representative issue?
No, Your Honor, I don't believe so. Not
On that issue, like I'm going to give you a
not on
chance.
that. Not on that point.
Mr. Hayes, you want to jump in here? You don't have to, but
Judge, just reiterate our previous points. I believe they're a party to the action. I mean, victims have a right to be present in the courtroom. Nothing that this court ever ruled, and the ruling on November 25th against that. Nobody's ever barred them from the courtroom. They have a right to be present. That right is always been for the victims.
yeah, thank you. I appreciate your position. Ms. Canepa, Mr. O'Brien, I haven't asked you if you want to make a record, talk on the thing.
On the victim
Yeah, like on this last discussion we had with Ms. Gall.
representation, yeah. And it's my opinion, I don't know if Ms. Gal brought this up. I think she may have, but there are a number of other victims present who have signed a form saying that they want TR to be their victim representative. So, to our knowledge at this point, there's no victim that is not in favor of him being the kind of spokesman. So, So yes, and I would say, the court's decision certainly substantially impairs the victim's rights, we believe. And so we would believe they do have standing at this time to at least present considerations for the court.
So the decision on designating a victim's representative is deferred pending today, so I'll get you a decision. I'm not just going to announce from the bench. Like, I hope you did hear me say I'm not interested in limiting victims' rights and don't want to do so inadvertently. Okay?
Can I just add one thing, Your Honor? Just per the law, and defense didn't offer any, I don't think this court has to interpret any law, and they can just take judicial notice that he is acting as a victim representative. As far as the victim definition of TR, though, that is a legal finding that this court would need to make, and it would implicate whether or not we have any rights when it comes to the change of venue. So I'm not sure whether the court plans to hear or determine standing at this point in time.
I'm going to let you explain how victims' rights articulated in the Constitution crash into the change of venues rules. I'm going to let you argue that.
Okay.
I'm not going to concede that you have the right to. That's the standing defense put up, right?
Correct.
And if I find you don't have standing, I just ignore everything you said, necessarily. But if I don't hear it, I don't know what I'm doing wrong. Right? Like, there was a pretty good argument with regard to, not agreement, oral argument with regard to whether change of venue is appropriate or not. I wrote a decision. Everybody's welcome to like it or not like it. It's not the job. But then I apparently didn't hear enough of your perspective. So I'm going to hear some more of your perspective, which does not imply anything other than I want to hear. There's a motion, but it doesn't necessarily imply that you have standing. Just want to know what I don't know. Make sense?
Yes, Your Honor.
Have at it.
Okay. So just procedurally, I think it makes sense to make a clear record of how we got here. In November of 2023, Judge Corbin issued a decision denying the defendant's change of venue request without prejudice. In September of 2024, the defense filed an amended motion for change of venue before this court. After Judge Corbin had retired, the state filed an opposition, and oral argument was held on October 7th, 2024. There were victims present. This court did identify that on the record. This court also identified that the state doesn't represent the victims, and the state very briefly said that the victim's right to be present and interest in attending the trial would be affected by a change of venue. I, as legal counsel for victim TR, filed a notice of appeal that was then dismissed because the decision from this court did not identify the venue. It said it will change the venue and identify it at a time appropriate. So based on that, it was a lack of a final appealable order. And then this court instructed a briefing schedule saying that victim TR should submit any documentation or support in regards to change of venue. And that is when victim TR filed a motion for reconsideration of the change of venue.
So do you want to put evidence on, or just your argument proper?
So I do not have one of the victims that would like to be heard here today due to school obligations with the orphaned children. So I have 3 statements that I would like to read into the record and submit as exhibits. I did notify the defense of that. I'm not sure whether there will be an objection or not.
Good to know. What do you think, Mr. Hazel?
Judge, one, I'm not sure who these letters have been from, if they're from TR or from some other parties. We've never seen the letters, never been provided the letters. Just briefly before the hearing today, indicated she had some letters, wondered what our position is. So at this point in time, we would object.
So you want to recess?
No.
Okay. Do you have copies that you might be able to show?
I do, Your Honor. I have 8 copies of each for the court and defense and state.
So, are they like marked with numbers?
Not as of now. I can identify them as exhibits if the court would like that.
No, I don't like to. I have to. If you're getting ready to introduce to the record something the court reporter needs to be able to identify. So call them victim 1, 2, 3 or victim ABC or whatever it is you want. Put a date below it.
They are each dated as letters, April 25th, 2025, but I can write the date on here too.
That'll work.
Would you like some stickers?
Sure.
So let's take a recess, standing break. Don't run away off the record.
Thank you, Your Honor.
Are they just neutrals? They say they don't.
They just say if it's like.
Oh yeah, so right,
D1.
something like that.
Okay.
Yeah.
That way they're not
Yeah, thank you.
defend, state.
Yeah. Was it male? That's a lot.
Right.
Is that how you're thinking?
Yes.
So am I. The question is where to come from. No.
I don't know how arrangements live here.
Too many spy movies. Yeah, no, right. Yeah.
They're here, where, regardless of face box, it's not just,
Oh, that's right. Yeah.
All right, so they're taking a break. So that was basically, I didn't catch the attorney's name, but she's for the victim, TR. So she's a victim advocate. And then the defense said sometimes Billy will be present, sometimes he will not be. So this was a motion for the victims. The motion was in response to the change of venue from the defense. So the Judge Hein, I think, H-E-I-N, I'm going to go with Judge Hein, he granted change of venue, but then there was no representation in that hearing, so that's what they're doing today. And she's arguing, well, that's going to be a hardship for these victims. They want to change it, like it's down towards Cincinnati. They want to change it out of Pike County. I'm not sure where, but it would be a hardship for the victims to travel. I guess they could be moving it up to 2, 3, 4, 5 hours away. Who knows? So that would be a hardship for the victim. So that's pretty much what that was about. She doesn't represent the state. Her sole purpose is the victim's voice is heard, and there are hardships with the change of venue. So then the judge was kind of getting on them, saying, well, what if there's cross, between you and the state? Like, who's representing the victims? The state representing the victims? Are you representing the victims? I'm going to be looking at you, and there may be times where the state doesn't represent the victim, and are you going to jump in? And then he's just like, it's going to be confusing. So he's just trying to sort it out. Hold on a sec. So this judge sentenced the mom and the son, Jake and Angela, back in January. We covered that. Let's see. Jake and Angela to be sentenced. So they were sentenced. She took a plea. Let's see. Let me see if I can pull, because we covered that. Let me see what their deal was. So Rita Newcomb, which was Angela's mother, she was charged with forgery and obstructing justice for her role. Angela Wagner, that's Jake's mom, she accepted a plea deal resulting in a dismissal of 8 aggravated charges. And then Jake pled guilty to all 18, including aggravated, admitting he wiped out 5 members of the Rhoden family. His plea removed the possibility of the DP in exchange for his cooperation. All right, so then, let's see. Angela's, she was 54, Jake is 32, right? And then George took took it to trial, and he lost, and I think he's facing life right now. Okay. Oh, he's serving 8 life sentences and 121 years on 16 other charges. Okay. So, judge, I know it was kind of shocking. So the judge, let's see, sentenced her to 9 years, counts 10 to 13, 9 years, count 14, 12 months, forgery, 18 months, 9 years, 12 years. So it was 30 years, but she got 6 years and 6 weeks for credit. So she got 30 years. But then with Jake, he gave him, remember he got up and he started talking about the Bible, and he was just going on and on. I now I don't live in misery. I believe God did this to me. I was in the darkness. The past is the past. Strive for the future. I was born again. I don't know if you guys remember that, but he was looking back at the victims. I think they got up and they walked out too, or the victims' families. I think they got up. And then the judge tells him, wrap it up. And he's like, Jesus has a cost: obedience, repentance, commitment. And the judge says that further demonstrates the role the court doesn't serve. All right, so he got aggravated. Let's see. He got 11 years and then 18 months for messing around with a minor, an SA. They thought he'd get life, but he gave him like 11 years or something like that. So I remember people were shocked that he gave him such a light sentence. All right, so I hope that kind of... Yes, Kathy. The Wagner's deleted. Here, let me go back here. So these are the victims. Those are the victims, right? So Wagner's family wiped out that entire family right there. And it was George and Jake that did the shooting. Let me see. Hey, DSN, how are you? Hold on a sec. All right, so the bodies were discovered April 22nd, 2016 by the sister of the victim. Bobby Joe discovered Dana when she came to feed the pets. Police were first alerted after receiving a 911 call about 2 bodies inside a home. Before police arrived, Manley discovered 2 more bodies in a second trailer. Her brother James went to go check on their sister and discovered a 3rd crime scene, so where the police found 3 more victims. Right? So 3 young children, ages 3 years, 6 months, and 4 days, were unharmed during the shootings, with the 4-day-old being found in the bed with the mom. 7 adults and a 16-year-old were among those that were taken. So the 4-day-old and the 6-month-old were placed under protective services, and the 3-year-old was put under the guardianship of his mother, who was not involved in the shootings. All right. So the victims are. You see them all there. So we have Christopher Rhoden Jr., Christopher Rhoden Sr. So we have a junior and a senior, right? We've got Clarence Frankie Rhoden, 20. Oh, thank you, DSN. Appreciate that. Thank you so much. Thank you so much for your kind donation. So they were all pretty much shots to the head. Every single one of them. Kenneth Rhoden, Hazel Gilley, Hanna May Rhoden. She was 19. Gary Rhoden was 38. Dana Lee. Okay, so it must have been Dana Rhoden. I have Dana Lee. Oh, Dana Lee Rhoden. Okay. She was 37. So they were all gunshots to the head. Pretty much. Found all but 1 were shot multiple times. 4 of the victims were shot once, twice, or 3 times. 1 was shot 4 times. 2 were shot 5 times. And the 8th suffered a total of 9 gunshot wounds. Jeez Louise, who was that? That might have been Christopher Rhoden. He had gunshot wounds to the head, torso, and limbs. All right, I got to pay attention to the stream here, you guys, because something's happening. Hold on. Okay. All right, any other questions I can help you guys out on? They did not harm the kids. Nope, the kids were not harmed. It was all the adults They did not harm the kids. And it was a custody fight over the toddler. Yep. It was Jake, I believe. Hold on, let me see. Let's see. Yeah, there was marijuana cultivation and cockfighting. So let's see. They were breeding chickens for cockfighting. They were growing cannabis. Let's see. I want to think that Jake was involved with the female. Hold on a sec. Let me. Is it here? I know we wrote this down. Let me see. Because he got smacked because so the young couple began dating when she was 13 and he was 18, and she became pregnant at 15 with Sophia. They broke up after their daughter was born. All right, so that was George. All right, so that was George. He took his case to trial and he got hammered. He's serving 8 life sentences. All right. So it was all over like a custody battle, if you will. So it was a custody battle over the 6-month-old and the 4-day-old child. So the 3-year-old Sophia was the one that was they got together and she became pregnant at 15 and she had Sophia. So she must have been she was like 18 when she was shot. She was 19, I guess. All right. I hope that helps a little bit. Yeah, I don't know, Irish Amy. I don't understand that. I don't know why the judge went so light on him. That shocked a lot of people. All right. Did I ever send you Jake's trial transcripts? Maybe. I don't know. I don't remember right now. We haven't really thought about this since January, to be quite honest. All right, we're going to get back to the court. All right. How was he never charged? I don't know. So, all right, let's get back to this hearing.
You got
Did you give the judge?
No, not yet. I wasn't sure.
well, wait, hang on, because
I'm
arguably,
approaching, we're not on the record.
yeah, but arguably you could say I'm not supposed to have those. No, get it?
Am I supposed to have it yet?
Yeah, so we're putting some
Put it down there, okay? Because that's the record. No, I don't want to like.
We've already addressed standing. You said you would make a decision. So moving on to change of venue, the victims have the right to be present and heard any time there's a public proceeding and any time their rights are implicated. With relation to the criminal offense, their rights are absolutely implicated by a change of venue. We are,
Which right is implicated?
Their right to be present. It's substantially impeded by a change of venue, specifically based on distance. We are not aware of what county this court is changing the venue to. And so had they addressed the court back in October, what they would have presented is that some of them have taken in the orphaned children that are now of school age and have to get on and off the bus every day. Some of them are blue-collar workers who can't afford to take off for a month. One individual...
Is that not the case in every criminal matter? Like whether you drive to Waverly or whether you drive to Hamilton, is it not the same implication? It's an inconvenience to have to come to downtown Waverly if you live in the northwest corner of Pike County.
Absolutely, it is, Your Honor.
Okay, so how do I sort out when the rights are violated? Does like just geography and I can take 25 miles is reasonable and anything over, is there an objective standard?
Your Honor, I think the right here is the right to be heard. Victims have a voice in the process, and these three statements explain what the effect would be of a change of venue, which is why I asked to proffer those in as exhibits. TR is here and willing to take the stand if you'd like me to direct examine him on the effects that this would have on him specifically. I wasn't going to do that. I was going to let the statement speak for itself. But he specifically speaks for his mother, who's also an 82-year-old elderly woman with health issues. And so, yeah, moving this out of Pike County would just be unfeasible. And it doesn't offer an opportunity for them to exercise the right to be present.
So does the defense have, first of all, you had a chance to look at the three exhibits, right?
Yes.
Okay, so do you have a position, Mr. Hayes, with regard to the court being made privy to the contents of the material as evidentiary matters?
As an evidentiary matter, no. I think the court can take it into consideration for whatever way the court deems appropriate.
It doesn't cash in or concede the standing issue, like I said.
Correct.
I want to state the obvious.
Correct. Just like a bond hearing, the court can take in other factors and other issues, so no objection based on that.
So I'll consider the substance. I'm never going to tell who to call. Now, never's not fair. I rarely call my own witnesses. So if you have witnesses, then you're welcome to call them. I'm not telling you to call them.
Yes, Your Honor.
I'll take
and
the letters, though.
Prefer not to. I would move to admit exhibits V1, V2, and V3. I can also read them into the record.
No, just give me the three, because Mr. Hayes has conceded that I can consider the substance. It doesn't concede the standing. So, yeah, thanks. Assuming, of course, you think that the letters don't violate the client's rights.
No, Your Honor, the letters do not violate the client's rights. It offers them a voice in the matter, and I do concede with the defense that it's the judge's discretion, it's the court's discretion to weigh this matter and all of the evidence presented. Again, I want to clarify that what I represent is the victim's interest and their voice in this process. They did not address the court in November, and that's why we're asking for a reconsideration of the court's decision. They do, in the Constitution, it says that their rights should be protected in a manner no less vigorous than the defendants. Defendants have to waive their right to be present at trial, whether that's in writing or on the record orally. Here, there's been a lot of choice and choose wording in both the defendant's arguments and in their written brief response. And, I would proffer to this court that there is no choice. If this moves outside of this county, that takes away their choice. Like I said, there are children involved.
Do you now understand why I will not let you not appear? You said you were entering a limited appearance, but you wouldn't go to trial, and I refused that. So you have to show up. Do you understand why?
Your Honor, I don't know that this court has the authority.
Oh no, I totally do. You entered an appearance. I'll stop talking when I'm talking. With all due respect, you don't get the option to not show up, because everything you're talking about that's so important has to be represented in the moment, not after the fact. If anything, I made a decision without you here that you later complained about. And I didn't even know was going to be the grounds for a complaint. So understand, it's in the record, now it's from my mouth, that you don't have the option to not show up. Every call of the court means you're here. Period. I'm going to remind you that I have the authority to make your life very difficult for not honoring that order. Because this is too important for you to opt in and opt out, to say when you think you're needed and when you're not needed, because these are big issues in my world that can't go unanswered at the moment. So if you're not here, you have a problem. Because this is so important, you don't get to opt in, opt out at your choice. Got it? There's nobody in this room has an option as a lawyer to show up or not.
Your Honor, respectfully, I disagree. I think that the decision that the contract that I signed with my client is for limited appearances.
That's fine.
We have 3 attorneys for the entire state. We don't have any funding for me to sit in a month-long trial. I cover 13 plus counties for the state, so that's just unfeasible. I also have a family in Cincinnati. So
it's a really good record to make. It's a really good record to make.
Yeah.
All of which I can't care about. Because what you just said applies to every other lawyer in the room. And me. At some point in time, our duty to the profession and to our clients exceeds our personal convenience and our staffing.
Not my family. No, Your Honor.
Okay. I get it. Good luck with work-life balance.
My client can waive my appearance, and he has. He agreed in that contract, and that was what the limited notice of appearance was filed for. My client has the right to do that. Me and my client have the right to contract my availability, but I think we're getting off track. I don't know that that's...
No. We're right on track. First of all, I'll tell you what I want to talk about, and then we'll stay on my track. And I respect your desire to have work-life balance, but the law is a jealous master. And we're going to get this right, because you showed up after the fact and complained about things I didn't do when you weren't here, and the whole second guessing can't happen moving forward. I'm giving you the privilege to ask me to reconsider a decision I already made. It's a privilege to hear it because I want you to advocate. But you can't advocate after the fact again. I don't know where you live and have a clue about children and family. I'm happy for you. But work-life balance is like a mirage. It's totally mirage. Now you have to go talk to your management. But I brought this up and it's on my list to make it really clear. Like Mr. Collins not being here without explanation for trial, he knows better. He 100% knows better. Like if you want to have a limited representation agreement with your client, that's between you and your client. I got nothing in that. Because I don't represent the interests of your client, you do.
Right.
And I'm not going to have second guessing after the fact with you gone. You're on record. And you want to withdraw and your client wants to sign off, then that's a different deal. But a limited representation is not happening on this case in this instance. So I'm just going to tell you that I already ordered your appearance all the way through. Figure it out. We're not going to trial next week because we're stuck in the Court of Appeals. But when the case goes forward, the more lawyers, the better.
Your Honor, I'm going to assume that my client's going to have standing then, at this point.
Oh, no, they don't have to have standing to be
I'm not sure I would represent their interests in this case if they don't have standing and I can't be heard anyway. So I guess I'm still waiting on a decision on standing prior to trial.
So if I say there's no standing for you to argue on behalf of the state, you're saying your client's no longer a victim?
I don't want standing to argue on behalf of the state. I want standing to assert my client's rights and any denial of those rights, which is the right to be heard when it comes to a change of venue that implicates their right to be present at the trial.
Okay, let's go back and let you finish now on the merits.
Okay, so they have the right to be present. I don't know that there's any indication or objection that they do, but that comes from both the constitutional amendment and the revised code. And all appellate districts and the Supreme Court that have taken up the issue of a victim's right to be present for the entirety of the trial have issued in favor of victims being present. I was on the argument of their rights to be protected in a manner no less vigorously than the accused. Criminal Rule 43 requires that waiver from the defense. And, victims also have a right to be present for the entirety of trial, so they're the only person that should be able to waive that presence. The letters that you're going to take into consideration show the substantial hardship. It basically takes any choice out of the matter. This is a poor county. These are blue-collar workers. These are elderly individuals with health concerns. They cannot up and move their life for an entire month. They don't have the resources, and it's just not feasible. So there is no opportunity for them to be present in another county, especially when, like Cleveland or Columbus, which I think were counties that were identified by the defense in their original motion for change of venue. There is no supporting case law in Ohio currently on this issue because, as the court has already acknowledged, this is new. We're in a stage where the victims' rights are up and coming. They're just now getting to the appellate courts for interpretation after the Ohio Constitution went into effect in 2018. There is a very in-line case from New Jersey that I cited in my motion. It was a capital murder case. The victims claimed that they could not, the surviving parent victims of the child deceased victim, claimed that it would be an entirely too much of a hardship for them to go to and from a different county that would cost them about 2 hours on the road each day when they had other young children to care for at home. In that case specifically, the state and defense had originally argued a change of venue. The trial court had granted it, and then it reconsidered based on these statements. They were affidavits in that case that were submitted by the state on behalf of the victim, and the change of venue was reconsidered and moved back to the original site or county. So I think that specifically is in line with what we're asking this court to do here, and it's to consider the victim's hardships in the change of venue realm. Again, on that choice, I don't think there is one in the circumstance. There were, eight individuals who were murdered in this matter. That affects a lot of surviving victims. This trial, we already know, is going to be very lengthy, several weeks, probably at least a month, and it's just not feasible. There is no choice for these victims to up and move to a hotel room, to drive to and from. Some of them might not even have, reliable transportation to and from Columbus or Cuyahoga or wherever this matter ends up. So I do think that I know you asked about a 25-mile radius. I don't think there is a perfect answer, but I think that the further away, the more hardship that there would be for the victims in this matter.
So do I ask your clients for financial disclosure and affidavits of indigency? If I'm supposed to be exercising parity, competing victims' rights weighed in the same manner as defendants' rights, do I not regularly ask defendants about their ability to afford a lawyer and make them fill out financial disclosure forms before I just make sure they have adequate representation? I mean, it's a hypothetical question, but like you just made a very important fundamental argument that's just poof with facts, void of anything other than conclusion. So do I make like TR, give me a financial disclosure form, list his assets and his liabilities, and I go through some comparison to federal income guidelines for the number of people in his household the same way I would for a defendant?
Your Honor, I think we're comparing apples to oranges there. One, victims aren't party to the case, and two, they don't have a right to
If they're not a
appoint
party, they
counsel.
don't have any right to argue a motion.
They do, under the Ohio Constitution and Revised Code section. They do have rights within the criminal proceedings, but they're not parties to the case. So they have privacy protections still.
Where's the privacy protection?
In Ohio Constitution, Article 1, Section 10. I don't have it off the top of my head, but they have a right to privacy in the Revised Code section. And under Criminal Rule 17C, any subpoena would have an opportunity for a motion to quash, and then if the whole Nixon test, hearing, etc. They do have a constitutional right to privacy, though.
Why don't you like to send everybody an email, including me, with you articulating the authority for that?
Okay.
Like, I'll take your word for it, but maybe that's not a good thing to do. I'm not really sure what I'm supposed to believe when people talk. Now, proper is one thing, but like you just made a fundamental argument that was conclusory. So I got to flesh this out. I don't ever ask a victim for financial disclosure.
Right. I don't.
But you just asserted economic hardship. And Mr. Hayes might not like the fact that I just assumed a fact that's not an issue. He might be fine with it. But I wouldn't ever let a defendant get a lawyer without signing a kind of affidavit saying he can't afford one.
Your Honor, I think this court has discretion to consider any hardship on the victims when it comes to implicating their right to be present in trial. I think the weight that you give that is, again, up to the court's discretion.
Keep going. Thanks.
I believe all I have at this point is that I just don't believe that there is any choice on this matter. The further this case moves away, the less likely there is any ability for these victims to show up daily, and they did in the co-defendant's trial. Even if those were half days and then they reported to work afterwards, they were able to be present. That makes a huge impact on the jury to see whether victims are in the courtroom. It also, with the live streaming, it assumes that not only the courtroom that this trial will be held in has strong internet accessibility and signal and all of the equipment necessary, but also assumes that each and every victim that would like to attend via live streaming has a smartphone, a tablet, a laptop, and also strong internet connection.
But if they didn't have transportation to the courthouse in downtown Waverly, is the court then supposed to send out an Uber driver?
No,
or
Your Honor.
Lyft? What's the difference between I got to consider whether you have a valid driver's license and a car, as opposed to I have to consider whether they have a tablet and internet service? I get what you're saying. I'm just trying to understand the scope. You're supposed to be the expert in victims advocacy, so I get the benefit of going to school on you. So if I'm supposed to consider their internet accessibility, is that any different than me having to hear an argument next month that somebody doesn't have a driver's license and the court owes them the legal obligation to send out a chauffeur driver every day?
No, Your Honor. Again, I think that's apples and oranges. This court made a determination that live streaming was sufficient to uphold their rights. You then instructed us to file on the briefing schedule to be heard on the issue, and I'm telling you that these are general concerns based on the decision that was made specifically. No victim is asking this court to afford them an Uber. Again, they're not a party to the case, and they don't even have the right to appointed counsel, so I don't think this court has any financial obligation to them, but it does have a legal obligation to uphold their constitutional and statutory rights. And so that's where that right to be heard comes in. And I think, again, there's a difference between a victim being expected to assert their rights in the county where the crime was committed, and again, that choice was made by the defendants, not the victim. The victim doesn't have any choice in participating in this criminal justice system. They didn't choose for these crimes to happen in Pike County. The defendant chose for the crimes to happen in Pike County, and therefore the defendant should answer to a jury of his peers in Pike County if that is a possibility.
Well, I'm a former crafty prosecutor, and Miss Kneppe could have picked a different county. So, in fact, the state picked the venue based upon the facts available and did a logical, fine job of it. It's not just like because an element happened here, you have to have it. She could have picked a different venue. We're dealing with the fact that that's her judgment, and it's her judgment. So, like if there's heartburn about location, maybe it's just systemic.
Your Honor, I think generally speaking, the crime is usually tried in the county where the crime was committed.
Yeah, but one of these crimes was committed in Scioto. So what are we doing in Pike? Her judgment, logical,
Yes.
educated, wise judgment. But her judgment nonetheless.
And I think the argument there would be that Scioto County is about 30 minutes away, and Cuyahoga County is not. So I think a big part of this is unknown how big of a hardship there will be until the actual venue is disclosed. But I think the point of this hearing today is to make sure that the victims are able to express the hardship that a change of venue would have on them. And if you take that into consideration and believe, that the venue should be Scioto County, then maybe in that circumstance, they are able to attend. That's not something that I can speak to on their behalf at this point. I'm just saying that the distance is, the more distance, the more hardship. And I think that's what their statements speak to.
This is a fascinating argument, because a whole lot of people want to know how this plays out. It's less inconvenience and equal participation, in my perspective, when I live stream everything that happens in downtown Waverly to your house, so you can do child care in your house without a car. And my accommodation, in fact, gave less inconvenience to the public and victims in particular. So now it's a question of perspective as much as anything else. And I live streamed for years.
Your Honor, in perspective to that, though, Jake and Angela, who are the key witnesses and were in George Forrest's trial, declined to be recorded and videotaped. So there was a whole week of testimony that if the victims hadn't been here in person would not have seen. And I think that's major. That's a huge consideration to make when it comes to live streaming and the convenience of it. I don't know that there is convenience if they're still missing out on the main witnesses testifying.
I'm just trying to tell you that there's easier ways to do it than being there. I've conducted remote trials where no witnesses are here, and half the lawyers are. And everybody agreed that was more convenient and more accessible than thinking you have to be in a physical space designated courtroom.
Your Honor, I don't disagree, and I think, live streaming and everything that came out of COVID and all the remote appearances and stuff are a double-edged sword, because a huge part of the defense's argument is the publicity of this case, and that's why it needs to be changed. But if we're arguing that everybody has access to internet and Peacock and Google, then I don't know what a change of venue does in this particular circumstance either.
How about this? Your dilemma is my dilemma. You're going to be wherever I am for the length of the trial. Unless, of course, I allow you to participate remotely and give you a live stream to your house in Cincinnati. So which one's the harm?
It depends upon the individual, and that's why the victims.
So it's the victim's decision?
No, Your Honor. The victims' voices should be considered.
Yeah,
it's not. They have a voice, not a veto. I would never say that victims' rights are, elite to the U.S. Constitution. I don't think I would have any credibility.
Well, go with the Ohio Constitution, because that's what we're talking about. Ohio constitutional rights for a defendant stacked up against Ohio constitutional rights for a victim.
that's a discretional weighing that this court has
I'll try not to screw that up
consider.
again, if in fact you think I did the first time.
Your Honor, I wasn't here. I was just,
Which is the point I already made.
yeah.
So, like, maybe I'll accommodate you and let you participate remotely, assuming you can waive that right.
Your
I'm
Honor, these
very
are all
serious.
questions that I don't have an answer to today, and I think depend on a lot of different circumstances.
Major understatement. You're right. Okay, so let's flip the switch, Mr. Hayes.
Judge, nobody's arguing that the victims don't have a right to be present. The victims can be present in the courtroom, the court doors aren't going to be shut, there's live streaming, the state can help facilitate some options in transportation if they needed to, but nobody's advocating that the victims don't have a right to be present. They do have a right to be present. In order for the victim to have standing, they must point to a specific right that has been violated. There's been no right that's been violated in this case. If this case proceeded federally, it would be tried in Columbus. You have jurors that have to be transported or find transportation from Ironton, from Portsmouth, to come up for jury duty, and witnesses that have to come up there. These happen all the time. This advocate cited State v. I'm going to spell this, Timmendequus. It's a New Jersey case, 737 AD 55. That case has no precedential value in Ohio. It involves a New Jersey statute. That statute constructed is broader than what was provided under the Ohio Constitution. It also discusses inconveniences to witnesses, inconveniences to the victim's family. That is broader than what is in Ohio statute. But at no point does the listed victims have the right to choose where the venue is, to choose where this case is going to be tried. We discussed, and I don't think I need to go through everything that was founded in this court's November ruling. The homicides that occurred in Pike County touched the heart and fabric of this community. It touched everyone. It's a small community. We've argued that. And if there's any example, any circumstances in Ohio, I've been practicing over 30 years, Mr. Collins has practiced longer than that, I can't think of where there would be another example for a change of venue in this case. Especially, this isn't the first trial. This would be the second trial in this county. But we've argued that, we discussed that, we talked about the saturation of the market and the individuals here. In reality, if we started to do a trial here, would we try to push through it? Is that going to, give us the right to a fair trial at that point in time? Then we have to step back and then reschedule and reevaluate our schedules and our dockets, and it would just be, extremely difficult to do. There's no way we can have a fair trial here in Pike County, So I ask the court, and we'll incorporate our previous arguments, our previous motions to the court. Even the advocate recently stated, we want the jurors to see, the victim's family. Well, that is an inconvenience. That's to try to change the balance of the scales here to give the state an advantage on that. So, Judge, we incorporate our arguments. I ask the court to not have a change of venue. I think with this hearing, and I think even in our previous hearings, this court took into account the difficulty in the listed families and victims in its decision. I don't think the court overlooked that. I think the court took that into consideration, even referenced it in consideration. I don't believe there's any abuse of any discretion of the court, and I can't picture another case that would have a harder argument for a change of venue than this case.
Thank you very much. Do you want to make any record, Ms. Knappe?
If the court pleases, yes, I would like to. Your Honor, again, much like Mr. Hayes said, the court knows the state's position regarding change of venue. We trotted that out in the briefing, and we argued orally in front of this court, and the court, considered all of that and made its decision regarding venue. However, I do believe that the victims' rights obviously were not fully represented at that time. While I did, in passing, make that comment about the hardship that would be not only to the victims, but to witnesses and et cetera, many of whom we did have to drive to court, as far as the witnesses. I do think this is new information. There's a reason why maybe the state shouldn't be representing the victims, because I'm not as educated and as proficient in all the victims' rights and the statutes and the case law surrounding their rights as Ms. Gilley is. So I would ask the court, we sincerely appreciate the opportunity for the victims to be fully heard today. And obviously she submitted statements on their behalf. But I would also ask the court to not only fully hear them, but to also fully consider this in effect, making it a motion to reconsider its previous decision. And I recognize that the court will likely have to engage in somewhat of a balancing test or whatever, because the court has already found that the defendant's rights are implicated by not changing venue. So, given the, some of the constitutional sites, revised code sites, and case law sites that Ms. Gall has provided, specifically that the rights of the victim are to be, I'm trying to find, protected as zealously as protected in a manner no less vigorous than the rights afforded to the accused. I think that kind of changes the landscape. Now again, what weight the court puts on it is obviously your discretion and the weight that you place on it. But I do think, given especially, of course, the state's position, that given that we used less than 1% of the jury pool last time for the county Pike, the factors in skilling have only resolved in favor of the state in that there's been more passage of time, so you get more distance from Georgia's trial and Jake and Angela's things, but also recognizing that those facts are going to come into evidence in front of any jury. The fact that Jake pled guilty and what he has to say, that's going to be, as the court has recognized, key evidence in front of any jury that hears this. So whether or not a potential juror has heard tale of that, again, the court's admonishment that they, can only consider evidence that this court deems admissible into the courtroom, and not those outside sources. Surely Jake and Angela's testimony are going to come into evidence. So, etc. Those also were not televised, in the first trial. So again, I think the potential damage, there's U.S. Supreme Court cases that says even pervasive adversive publicity does not necessarily parlay into a presumption of prejudice, right? So we still have the opinion that the court should go through those cases and try to do a searching and careful voir dire, especially because of the victims' rights that absolutely would be impacted, Your Honor, and adversely impacted to the point that some of them will not at all be able to attend hearings that they have a right to be present for. And there is a difference in televised, right? Because they can't converse with the prosecutor in between. They can't observe the jury. They can't observe the defendant. They can't hear statement of witnesses that elect not to be recorded and televised.
So does the prosecutor now, as a matter of law, have a duty to consider venue vis-a-vis victims? You had options with regard to venue. And in some cases, the options might be in a pattern of corrupt activity halfway across the state. So does that then put on the prosecutor, Mr. O'Brien's long-time career, to consider victims' availability to the courtroom when the prosecutor picks the venue? I mean, if you carry this out, is that what you're saying?
I think that would be likely factor that you should consider. I mean, we certainly consider where the evidence is, where the witnesses are, where, because you want to be able to optimize your ability to effectively prosecute somebody.
Quality of the investigative agency, court facilities, all those, no, it's all baked in there, let's just admit it, 100%. We look for effectiveness, we look for convenience. How many times have you shopped judges don't answer out loud? Right? We all do it, we all know what goes on, it's not wrong. I'm just trying to decide if now you're taking on another legal burden as the state's representative to consider victims' rights when you pick the convenient venue where you have a much better chance to obtain a prosecution. We all get shopped. It's not wrong.
Yeah, I mean, again, how much weight that carries is at the end of the day, or, it's certainly not the single deciding factor, right? So
just, I'm going to hear you say, yes, you now have to consider victims' interests when you select venue. That's my conclusion of what I just heard you say.
Yeah.
Okay,
That's fair, that's part of everything.
I don't know if I agree with that,
In this case, the 3 of the 4 crime scenes are in Pike County, and at the time, we thought the 4th one was, and so it made most logical sense for Pike County, and that, thankfully, also aligned with the victims, because their family lived in Pike County, as most of them do, not all of them do.
Given the oddity of the investigative resources available in Pike County at the time, it might have been better not to investigate this case here. That's just like a rhetorical question.
Yeah, I mean, ultimately, we need to as prosecutor, I need to make sure that the judge is going to agree that venue is properly placed in whatever county we select.
But you don't lose the indictment, you just lose the venue. But it was awkward, to say the least, when the local investigative agency wasn't appropriate to be involved because of third-party anomalies. You weren't there, I just heard about it.
Right.
I look at most of the world from your chair. I only spent 3 years over there. I spent 14 years over there before I came over here for 27. All these perspectives are valid. I'm not going to take on the duty to consider victims' rights if I'm a prosecutor when I select venue, until you all sit over there and yell at me for not considering something that you wouldn't want to consider either. I think if you had a choice to not have this case in Pike County at the time and gave it a tactical evaluation, you might have considered going to a different agency in a different county to try to get all the help that you couldn't get here because of the anomaly. You did a fine job with what cards you were dealt. So this is all argument, but people watch these arguments and want to know, some adjoining prosecutor is probably glad you picked here.
Oh, for sure.
Yeah, no doubt about it. Nobody
all
asked.
the counties that didn't get picked are happy.
Nobody asked for this. You involved other counties with regard to investigations, far-flung, to steer clear of the anomaly. If you thought you could have just landed in one county and not had to deal with the far-flung, that would have been even easier for you.
Yeah, I would say convenience to the prosecutor is probably the last thing to be considered, however.
That's a really good public statement to make.
It's true.
That's subjective. What else you got?
I would also note, Your Honor, that the first trial was live streamed, and yet the victim still chose to be here, which I think is a very good sign to the court. The value that they place on that right to be present is they did have the ability and the convenience of just sitting at their house and watching this, but they chose to be here. And as this court knows, that was an extremely long trial. From when the evidence starts, it was 2.5 months of testimony, not to mention the selection of the jury. So there's no question, Your Honor, even obviously Mr. Hayes agrees that they have a right to be present. I would agree that there is no substitute for being present. And while we appreciate the court's, thoughts on how to try to solve some of those issues, we submit that that's not sufficient to that they have this strong desire to be present, and that anything other than being able to be present. And I don't think that the court, I understand what the court's getting at, well, how do I know this is going to be a financial impact, and blah, 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 blah. Obviously they're not asking the court for court-appointed attorney or anything else, that the court needs to make that assessment. I don't think it takes much more than common sense, though, to believe everything they've written in here, right? That, one of the victims talks about, he would come for half days, which is you're able to do if you live in the same county as the case is happening. And so just the ability to get back and forth to court, drop kids off at the bus and be there when they get off the bus and all that stuff, obviously is doable if it's in Pike County, and not doable if it's much farther away than Pike County. So again, Your Honor, given the fact that the state does not believe that there's a presumption of prejudice, which then reverts back to this court at least trying to see the jury, coupled with the interests of the victim, which at least the Constitution says should be pursued as vigorously as the rights of the defendant, I would ask this court to reconsider its decision on the venue, but again, as Judge Corbin did, without prejudice, so that if it appears insurmountable, this court still has the ability to change it.
I'm not going to run around the room again to let everybody rebut. I'm going to move on, and maybe the rest of it goes a lot faster. I mean, honestly, Ms. Gall, this is what I wanted to hear, because you're the specialist. I had lawyers ask me one time why I would grind them so hard when I would rule in their favor. And I told them after the fact that I grinded them really hard because I wanted to see how good their argument really was. So if you thought I was grinding you, it doesn't imply that I'm opposed. It doesn't imply anything. Like Ms. Canepa coming at me going back at it, that's how we get better. Right?
Yes, Your Honor.
So don't misunderstand body language or figure, whatever that means to you. On the list was also the question of severance. So we got to back up before that, because there's a motion with regard to other acts, evidence, other acts. We argued this before. Memory serves me right. January we had discussion. I think I gave 14 days and 14 days, and Ms. Anstead, you made a compelling argument and gave me a list, if I remember right from my notes. But I didn't want to get to things if you still wanted to brief or be more specific. So I just want to close that book.
Thank you, Your Honor. We have researched the issue of severance, some case law on the issue. At this point in time, we're not planning on filing a motion for severance. There's a lot of interaction between that issue as well as 404B issues that we'll continue to object and raise issue to as proceedings go along. But at this time, we're not anticipating filing a motion.
Okay. I kept your list from the last time where you sort of gave me these would be appropriate. I'm going to still have that in the notes, because I was the one asking how this plays out, because you're asking me for a really nicely wrapped, tightly defined other acts decision.
And the basis, and the basis that I provided at the January date was founded in the 404B philosophy and the rules under 404B, which we believe we'll be able to achieve our goals, our strategic goals, our legal goals through arguments under that rule and the case law under that rule. As far as filing the severance motion now, strategically and based on some research, not prepared to file that at this point in time.
Are you withdrawing the 404B motion?
No, Your Honor, we're not.
Okay, so I'm right back where I was. Because I brought up severance in the context of how do I give you this tightly defined, well-answered 404B decision? And it all depends on what the elements of the offenses are. Like, you don't have to change your position. I'm just saying I'm back where I was when I brought this up.
And I don't intend to change the position, although this is an ongoing, it's a motion in limine, the 404B motion. So this is something that will be continued to be evaluated and argued as we go based on what evidence is being presented or attempted to be presented. So that conversation will continue, but with regard to a severance motion, not anticipating filing that.
Thank you very much. Mr. Bryan, you want to run this?
On that issue, Your Honor?
Yeah, on severance.
Well, I think as long as they haven't filed a motion and don't intend to file a motion, I have nothing to add.
Yeah, but I asked for it, which I'm allowed to do. So, like Criminal Rule 14, the context is they want me to say what's admissible testimony with regard to other acts, and other acts immediately implicates what the charges are and relevance. So like they get hooked together. They're
Well, at least my thought is, Judge, that other acts will come in whether or not there's a severance or not, because of part of the ongoing conspiracy that occurred, and therefore they would be admissible under 404B whether or not there's a severance.
okay. Now, am I supposed to let Ms. Gall argue on behalf of Criminal Rule 14?
I don't believe so, Your Honor.
Why not?
Because she's in here for the victim who's not a party. That's an issue related to the issue of severance and or 404B.
What do you think, Ms. Gall?
Your Honor, I am not educated on this motion to sever.
That wasn't the question, it's whether you
It's
have
not something that I plan to weigh in on. I think that this doesn't implicate a victim's rights. Victims don't have a right to present evidence at trial or try the case.
Okay. Another run at it? Anybody? Mr. Hayes, you're good? Okay. We need to talk about scheduling, which we can do off the record, because it's still set for May 30th. How about, just for my benefit, an update on where we are in the Court of Appeals?
Here, it's my comments. May I?
We're still on, right?
Yes.
Yes, yeah. We're still on this issue.
May it please the
Thank
court, I believe they picked the final oral hearing date of June the 12th. That was agreed to, I believe, by the government's appellate attorneys and our other co-counsel, Mr. Goddard. And I asked Mr. Goddard in terms of, in this type of appeal and this type of urgency, what he believed the result would be. He believes there'll be a decision within 30 or 60 days, but he qualified that by saying, however, I'm usually wrong on those things. So, but because of the nature of this appeal and the urgency of this case that the court has put on there, but yeah, the oral arguments are due the 12th. He believed the decision would be made within 30 to 60 days after.
If I might address that, Your Honor, I'll take it over on that estimate.
But then, the over, Your Honor, depending on them, what happens is if they rule in our favor, I'm sure they're going to appeal to the Supreme Court, vice versa, I'm not sure. But, and then again, with the victim's right advocate, who knows in terms of what gets appealed there. So, but just the basic information is June 12th of the oral arguments, and hopefully a decision will be within 60 days.
So this court doesn't make available documents online, so it's hard for me to snoop or actually find out what legal issues are going up. All the assignments of error start out the trial court erred. I'm good with that. It's just how we do it. So in the interest of not erring, I was trying to figure out whether anybody argued invited error, which always circles me back to the dilemma between where you sit and where I listen. So was that even briefed?
I don't believe so.
brief, you know?
I don't believe so, Your Honor.
But don't take this personally. Like, I like lawyers, maybe because I are one, and we think alike or trained alike, and I tend to believe what you say, but I'm getting hoisted on the Court of Appeals pewtered for doing what you said you were going to do, which I consider to be like invited error. Now, I'm okay if they don't consider that invited error. I'm 100% good with knowing what the Court of Appeals says because I follow what they say. But moving forward, I always have the ethical dilemma, professional dilemma, of whether anything you just said for the last hour and a half is anything I should believe. Nothing personal. We do it all the time. Our professional representations, our character, our ethics have meaning, hopefully value. You know, I heard you say, Ms. Anstead, that at the moment you don't have a motion to sever. And previously you answered my question about what could be a place to sever. And you're walking it back, but you could resurrect it later. I get motions in limine. You didn't do anything wrong. But if I'm supposed to be driving the bus and have some idea of where we're supposed to be going, you don't have to like it, but I pick the direction. Because I get stuck with the trial court erred. If I drive the bus or if you drive the bus, it's always I erred. So like I'm more proactive. Strike that, engage, no, attentive to where the bus ought to go. And I will continue to do that because in the end, we got to be ready. And Mr. O'Brien might be right on the over. Not a betting man, but that's a pretty prudent wager, perspective, or whatever. They got more than one case too. And so do most of the lawyers in the room. So I will wrestle with the professional dilemma of believing what I hear. Anything else on anybody's list?
Yeah, just two minor things to update the court. First is with regards to our client's hearing deficiency. Through his family member, we bought a device that we thought would cure that. It did not. I then met with an audiologist in Columbus, Ohio, explained the product, explained what was going on, and then called the Pickaway County Jail, both the medical department as well as administration. They don't have someone who regularly will assess hearing, but through Ohio State has a program that goes into the prisons on a regular basis in some jails. And I was able to obtain a person, an audiologist, who will go in on May 7th, as long as I'm there, to have the hearing check. To give the court an update, it's probably about $6,000 to $8,000 for the hearing device that the audiologist thinks would probably be necessary along with a microphone. So I want to make the court aware of that. And then Pickaway County indicated that as long as one of the three of us was with them, that they would accommodate the best they could in that assessment. Normally they send the people out to be assessed at a different place, but they didn't seem inclined to want to do that in this case. So I believe the Ohio State audiologist will go on May the 7th.
So you're saying it's an employee of Department of Rehabilitation and Corrections?
It's an employee associated with Ohio State, and they...
Ohio State University.
Yes, Ohio State University has a clinic that provides this service to county jails as well as to prisons, I believe, as well. So they have some type of relationship with that. That's as far as I've made it. The audiologist I was initially working with works with veterans, and they contacted the Ohio State individual and said that, yes, they've done that before, and they would not have a problem doing it.
So are you aware of this issue, Ms. Kenneth?
I mean, Mr. Collins brought it to us, our attention.
Yes.
He's been very upfront. And I know that the court said you might make some inquiries. And I guess it's the responsibility of the jail to provide medical... I mean, the bottom line is, speaking of indigency, his family is not poor.
Okay.
Let's not.
Could be accused of being a millionaire.
He is,
Family is not the test.
He is.
Well, carry this out, because now do I have to get an affidavit of indigency from the victim's family?
Well, only
No, I
when-
get what you're saying.
The only reason I said that is because Mr. Collins made a comment, I think, in his email that he couldn't find a family member that would finance
Yeah,
this.
no, I don't.
But-
His family's got nothing to do with it. They got no legal obligation.
I think when he's in custody, I think the jail is responsible.
Yeah. So here's my answer, because I did what I told you to do. Nobody that works in jail thinks he's got a problem. No, so you can do what you want to do, and I'm happy you're proactive. Like, I totally like this. But at some point in time, the question's going to come down as like a convenience or a necessity, right? Like, from a practical standpoint, nobody there has ever experienced, charted any hearing deficiency. So in their world, they're a little skeptical.
understood, just so that for the court's background, from the day we first met him, it's always been an issue on one side. I can't hear us, he returned, and we had to talk about it. And then the second is to update the court, Your Honor. We had a very productive meeting at my office with Mr. O'Brien and Ms. Canepa. I think we've narrowed down potential stipulations and probably cut out 30 or 40 witnesses who might not be necessary. I would only ask the government was going to provide us with those. We would like to try to get them in writing and then to make sure our client signs off on those. We are in the process of doing that as well, Your Honor. But that was productive in terms of, I think we cut out 30 or 40 witnesses, correct? Stipulations, right? So just update the court on that as well.
Music to my ears, or at least one ear. Anything else?
No, Your Honor.
Thank you. From the state, Ms. Gull, anything? Okay, so let's go off the record and find dates, scratch our heads. Thank you, Joe.
Thank you, Your Honor.
You're welcome.
All right, so that concludes our coverage of Billy Wagner, Ohio versus Billy Wagner. Judge Hine is 69, and yes, 70 is the cutoff. He is retired, and they appointed him last August. So there was another judge that was going to be appointed, but they decided to appoint him. And he comes from another county. So let's see. Let's just kind of go over what. So the victims, I think her name ended up being what was he called? Miss Ryan? No, Miss Gall. I think her last name was Gall. He called her a couple times that. So she was basically just talking about the victims. So he changed the venue, right? He put in a change of venue, and she's arguing that that's going to put hardship on on the family. There's a matriarch. She's elderly. I don't know how old she is, but they say she can't really travel. And I posted the difference. Cincinnati is probably the closest. It's like an hour and 33 minutes. It's like 93 miles. Columbus is around about the same. Cleveland is like three or 4 hours. You know, it's pretty far. You know, for them to move this to a larger populous venue. So for people to do that, like if I had to drive every day, 90 miles every day because, you know, my brother, my sister, you know, were no longer around and I wanted to come to the court, I wouldn't be happy. That's not cool. And then they can't afford a hotel, you know, this is supposed to be a month-long trial, you know, that they're not going to be able to afford hotels, you know, so I can understand that. So she was the victim advocate. She was basically just arguing on their behalf, saying they have a right to be there, and you changed the venue and they weren't there. So she's arguing that. He said that it's still set for May 30th, but that's going to get kicked down the road. I don't. They're in appeals. You know, there's so many things that are still happening with this. I don't think it's going to be May 30th, but right now it's on the books for May 30th. But I just don't see that happening. So anyway, so that's pretty much it. We have got a new trial for you guys. It's starting on Monday, and it comes out of Michigan. So we're going to do some pre-trial prep starting in 8 minutes. So I'm going to say goodbye for now. We have a redirect on for you, going over to this new trial that is going to be really interesting. I think you guys are going to be interested in this. It's Christopher Shore. He's an officer who shot and took out another person. So it's going to be one of those trials. So anyway, we have a brand new trial for you starting on Monday. Jury's been seated. They sat them, I think, yesterday, Wednesday or Thursday. They sat them, I think, yesterday, and trial will start on Monday. So I will say goodbye for now. In 5 minutes, we're going to go live at the top of the hour. I'm going to take a quick break. And what we're going to basically just do, we're going to go through all the pretrial hearings, the news reports, and get you guys caught up on what's going on with this. So thank you to Aaron for setting up all the graphics. Thank you to our mods. Thank you to chat for being with us and being respectful to each other and courteous. And we will see you guys in 5 minutes. Does my outro work here? I don't think my outro works here. All right, I'll take it over here. All right, guys, I'll leave you with Super Ball. There's a little Super Ball. Super Ball sleeping all nice and... Oh, let me get it focused. There we go. All right, so I'll leave you with that. We'll see you guys at the top of the hour, 5 minutes. See you then. Thank you for joining us. Bye.